Okay, I'd like to call to order the regular meeting of the Board of Trustees for March 24th and 25th. It is 2:27 p.m. Can we start with the roll, please?
Broughton.
Here. Here, in case you didn't hear me.
We can't hear you, Mark.
Here.
All right.
Chen.
Here.
Cisneros.
Here.
De La Cruz.
Here.
Delenn. Duran.
Here.
Stalag. Shelby.
Present.
Soul.
Present.
Stallings.
Here.
Tony.
Present.
We have a quorum.
Thank you, Madam Secretary. This meeting is being conducted in a hybrid fashion. We have folks here in the room in Los Angeles and folks on the Zoom. Members of the public who would like to address the board on an item on today's agenda or any item in our jurisdiction are welcome to do so at this time. Please indicate your desire to speak to the board by using the raise hand function on Zoom, *9 if you're on the phone. And we'll wait to see if there's anybody who wants to address the board.
At the moment, I see one hand raised from Tom Gordon.
Okay. Mr. Gordon, please activate your mic and you'll have up to 3 minutes to address the board when you're ready.
Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working to make the legal system more accessible and affordable. It is great, by the way, to see a lot of people in the same room together. It is a wonderful change from the previous times I've been here. I'm speaking about the process of changing the makeup of the Closing the Justice Gap Working Group. The member, as you're aware, the proposal before the board is to remove some members because of their lack of California-specific experience. Those members were nominated to the working group because they brought particular expertise to the process that the working group was undertaking. And losing those members deprives the working group of that experience. Fortunately, the Board of Trustees has already approved a protocol for maintaining that expertise in the event of members unable to serve. In its November 2020 resolution approving the original members of the committee, of the working group, the board provided a means for filling vacancies. Specifically, it said that if a vacancy should arise prior to the working group's completion of a final report, the board executive committee approves the list of alternate applicants as set forth in attachment B. But if the vacancy arises from a member who is designated by a nominating group or organization, the board authorizes the chair of the working group to make an appointment by soliciting the nominating group or organization to designate a replacement. And in fact, this is what happened previously when Bridget Grammy left the working group upon joining the staff of the board of the bar, and when she was replaced by Andrew Arruda as the rep from the ADL's working group. So what I would suggest, James Sandman's spot was as a representative of a national legal services organization. This was specifically a role for a national figure. Fortunately, among the recommended alternates is Shelley Skinner, who is from California. And I would recommend that the board approve Ms. Skinner to fill James Sandman's spot. Similarly, Crispin Passmore's spot was for the regulator, serving as a subject matter expert regarding the development of a new regulatory structure for sandbox participants. And among the alternates for that position are Lucy Ricca, who is already on the working group, but also Malarca Cruz, who is from California. And so I would recommend that the board approve Ms. Cruz for that, fill Crispin Passmore's position. Finally, John Lund's spot was as the representative for the Utah Regulatory Reform Task Force to facilitate alignment, I'm quoting, between the California and Utah efforts where appropriate. And again, it's expected that the Utah Task Force will be able to select a nominee for that replacement. So I would recommend that the board ask the Utah Task Force to provide a nominee with California-specific experience if possible. Thank you. I appreciate your time.
Thank you, Mr. Gordon. Do we have anyone else who would like to address the board?
I see Justice Brian Curry has hand raised, but maybe that's to participate in the discussion.
I suspect that it is. Good afternoon, Justice Curry. I know that you are slated to speak to us on an agenda item very soon here. Let me ask you if you were seeking to speak to that item or just an item of regular public comment.
Thank you very much. I was just letting you know that I'm here, and I'll wait for my turn. Thank you very much.
Thank you, sir. We'll hear from you just a couple minutes. Okay, seeing no more public comment, we will move on to item 10, the approval of the minutes for January 20th and 21st and February 25th of 2022.
Mr. Chair, I'll move that item.
Motion by Stallings,
I'll second.
second by Cisneros. May I have the roll, please?
Broughton,
Yes. Yes.
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz.
Yes.
Delenn, Saleg, Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. I have a short chair's report. And then without any objection, I'd like to move the item that Justice Curry is here to speak to us about ahead of the consent calendar so that we can let him get on with the rest of his day. My report is just a few points. First, I'm sure all of you have heard the news that as of 2 days ago, we have a new justice on the California Supreme Court, the first Latina ever to be appointed to that position, former, well, not former, but now Associate Justice Patricia Guerrero. Certainly a proud day, I'm sure, for her and her family and for folks hailing from San Diego and Imperial County. Wish her a very successful tenure on the court and look forward to meeting her hopefully someday soon. The state bar administered the bar exam in person just come past February. And so I'd like to offer my thanks to our admission staff who took on that, what it would normally be just a regular old effort, but certainly in light of where we've been over the past 2 years, certainly was quite a Herculean effort. And so thank you for all your hard work, folks in the admission staff. As all of you know, we've got several ongoing efforts on regulatory reform, expanding access to justice in California, and strengthening the bar's own disciplinary system, some of which we've heard about at the Regulation and Discipline Committee. There's already been reference to the Ad Hoc Commission on the Discipline System, the Closing the Justice Gap Working Group, the Paraprofessionals Group as well, has gotten a lot of attention and discussion lately. And I just wanted to once again thank the dozens, if not hundreds of volunteers and state bar staff who have worked very hard on all those sometimes complex, sometimes controversial issues, but certainly I think all with an eye towards what we're here to do, which is to protect and serve the public. So my heartfelt thanks for all of that work. Finally, I think many folks know that our esteemed General Counsel, Vanessa Holton, has announced her retirement. And so the bar is launching a search for a suitable replacement. Nobody can fill Vanessa's shoes, but certainly we need somebody to take up where she's leaving us off. And so those of you who know of a qualified candidate or know folks who know qualified candidates, please encourage them to get in touch with our recruiter, the Bob Murray Associates firm. There should be some public information being posted relatively soon in the coming days. The search committee has already had its first meeting to work on the job description and to lay out a calendar. So it's going to be some pretty intense, pretty quick work, but certainly very important work for this board. Just spread the word near and far to your networks, please. And that's all I have.
I wonder, Ruben, if you want to mention that the timeline that we've contemplated is having board interviews for candidates in June, early June, before Vanessa leaves us. So.
Yes, thank you, Leah. So that you will recognize that is not our regular board meeting schedule, right? We meet every 2 months normally, so we're gonna ask the board's indulgence to call a special meeting, to attend a special meeting for that very important purpose, and we'll give you more details as we get closer. Leah, did you want to do your report before we take up Justice Curry's item, or should we wait until after the consent calendar?
We can wait.
Okay. All right. So again, with the board's permission, I'm going to move item 704 up in the agenda, which is discussion regarding California Civility Task Force proposals and a proposed action. Randy DeFontorum is designated as our staff member to present on this item, I'm sure in conjunction with Justice Curry. So if we could get all the folks where they need to be, we eagerly await your report.
Good afternoon, members of the board. Randall DeFontorum, Office of Professional Competence. Agenda item 704 presents a staff recommended action plan for the State Bar's consideration of proposals to enhance attorney civility that has been submitted by the California Civility Task Force. The Civility Task Force is a joint project of the California Judges Association and the California Lawyers Association. With us today is the chair of the task force, Justice Brian Curry, Associate Justice, Court of Appeal, 2nd Appellate District, Division 4. And I will yield the floor to him to give you a little bit of background on the report itself.
Thank you, and good afternoon to all of you. It's such a pleasure to talk with this group. The work that you do, both as members of the Board of Trustees and as staff members of the State Bar, is so important and so invaluable to the state. And you are such a wonderful justice partner to have with us. So I thank you for your service and thank you for the opportunity to talk with you today. You've received this terrific staff report from Mr. DeFontorum, which remarkably is able to encapsulate all of our verbose report down into 4 pages. But I'd like to tell you a little bit about the task force itself and then the proposals that we came up with. The task force has been in existence since 2019. It was formed as a result of a meeting of about 100 lawyers from across the state under the auspices of the Association of Business Trial Lawyers to talk about the subject of civility in the legal profession. Civility in the legal profession has been a long-standing topic. It's a nationwide issue. The issue is not civility so much as incivility. And it has a real impact on lawyers and the public. Incivility increases stress, it increases transaction costs. And what we have found is that it is heaped disproportionately upon members of the profession who come from underrepresented groups, women, young people, people of color. And it's something that the courts have tried hard to deal with, but so far unsuccessfully, and that the bar has taken a real and consistent interest in dealing with. The task force consisted of about 40 well-known, impressive lawyers, judges from across the state. And we've come up with 4 key recommendations, 3 of which directly impact the work of the State Bar. And those are highlighted for you in the report. But the first recommendation is to mandate 1 hour of the existing MCLE training to be devoted to civility with a focus on ending what we call bias-driven incivility. The second proposal that we made, and this is outside your purview, would be to increase training for judges on how to model and deal with civility. And we've made progress on that front. I've been talking with the vice chair of CJUR, which is the Judicial Council committee that deals with judicial education. They're very interested in working with us on that particular proposal. The second proposal that would deal with the State Bar is to enact meaningful changes in the State Bar's disciplinary rules to make it clear that incivility is a prohibited activity for lawyers and that being civil is not inconsistent with being a zealous representative of one's client. And finally, to require all lawyers, not just those who've taken the oath since 2014, but all lawyers to on an annual basis, reaffirm the civility portion of the oath, which says, as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. So I thank you for listening to my little talk about our report. And I think really the focus of your meeting needs to be, how is the organization going to deal with these proposals, and what timeline would you put in place to deal with the proposals? We offer, as the Civility Task Force, all of our support and expertise and willingness to work with you on implementing these proposals. We can bring together subject matter experts and I think be a big help in the work going forward. And we certainly do appreciate your attention and your commitment to the subject. Thank you.
Thank you, Justice Curry, and thank you to all the members of your task force who have put in what I gather to be some very intense discussions on this issue. I note that your two vice chairs are here at this meeting with you. To my right is Brandon Stallings, also vice chair of the Board of Trustees, and up on the screen is Heather Rosing, as second vice chair of your effort. And so to the three of you, truly, thank you for the work that you've put in. At this point, is there a discussion, or let me just ask, are there any members of the Board of Trustees who have questions about the agenda item as it's been presented to you? Specific action that you're looking for, Justice Curry? Brandon, any comments?
Thank you, Mr. Chair. Yes, if I can make a couple of comments. I had reached out to Alan Steinbrecher, former chair of the State Bar Board of Trustees, because this really was one of his projects that he started working on with Justice Curry. So if Alan is listening, thank you for this. Also to Pat Kelly, former president of the Board of Trustees. We really sought to build upon the work that he started back during his presidency. I also want to note that this, I think, is the first full collaboration between the California Lawyers Association and the State Bar. And I think no better cause could be brought up with these two organizations as helping lead this effort. So we brought on Heather Rosing, and she has provided immense support and incredible work product to a very challenging area regarding the rule of professional conduct. Got to work with Judge David Wolf from Kern County on the task that I took on, which was the civility oath that new lawyers are required to take. And we're asking that all lawyers now cyclically reaffirm this civility oath. And then it's been a real pleasure to work with Justice Curry and to take advantage of his just immense expertise in this area and the people that he's able to bring on board in this effort. So I think the report really speaks for itself and really highlights the issue. And then, not that this is a solution, but these are potential steps towards addressing incivility here in California. Also want to thank Chris Andreessen. She provided a lot of technical assistance in this endeavor. And then Emilio Veronini, past president of CLA, and Jeremy Evans, the current president of CLA, also provided a lot of support. So we hope that the work product is to your liking. I've talked with staff about an issue of whether we should have a timeline for these three proposals. And so I don't know if Leah or Randy, if you guys want to talk about potential timelines for these proposals and the way that they correlate with other proposals that we've received, and just whether you think a timeline set by the Board of Trustees would be prudent at this point.
Sure, and I'm happy to have a timeline. I just think it may be a bit more extended than folks might like. But Randy, do you want to talk a little bit about some of the other asks that we have with respect to revisiting our MCLE requirements and other relevant issues that we're going to try to incorporate in?
Yes, so we reviewed all of the proposals, and they are very much worthwhile. They are all consistent with the past efforts of the State Bar as a key player in the area of civility and professionalism. they are rather distinct. And so you do have a proposal to amend the attorney oath, which is codified in the rules of court. You have the changes to the rules of professional conduct, which are rules approved by the court, but they are a different place. They're the rules of professional conduct. And then you have the MCLE proposal, which is authorized by statute and also regulated under the rules of court and state bar rules. In order to work each of these up, we would be looking at perhaps a time frame that would be driven by what is involved with each of these things. And so, for example, with the rules of professional conduct, the action plan in the agenda item seeks to refer this to the Standing Committee on Professional Responsibility and Conduct, COPRAC, and COPRAC's schedule, its workload, and perhaps the need to consider legal advice, perhaps on some of the issues that might be of a constitutional nature with regard to civility changes to the rules of professional conduct. I think you could have a rough estimate of at the outside 6 or 7 months, because they would need at least 3 meetings to review the proposed revisions and to actually come up with their own recommendation. I did work with the staff attorney in our office, Andrew Tuff, and we did a preliminary sort of pass through those rules and sent some, courtesy technical feedback. I think it was submitted to us by Neil Wortley, a former member of chair of COPRAC, actually. And so I think we can jumpstart COPRAC's consideration with some of that work up that the staff has already done. On the attorney oath front, I'm glad that Brandon gave a shout out to Carissa Andreessen, because she, again, worked with staff and Office of Professional Competence and actually has developed language for a possible rule of court to implement that change. But that one also would need to be reviewed. We'd coordinate with all the appropriate stakeholders, including court staff. But that one might be one that we could turn around sooner in a time frame, maybe within 6 months. The third one, the MCLE change, while the specific proposal from the Civility Task Force, taken in isolation, it might be something we could turn around sooner. The State Bar is really entertaining a variety of proposals to amend the MCLE requirement. The civility proposal would be tucked in nicely within the existing 25 hours every 3 years, but we're receiving other proposals for changes to MCLE. We have a recommendation from the San Diego County Bar Association, as an example, to consider expanding the definition of competency and mandating an additional credit for competency. We've received recently a proposal that the MCLE requirement be modified to allow lawyers who participate in mock trial activities, judging mock trials, assisting the students in mock trials, which is actually qualified for credit in other jurisdictions, Illinois, New York, but not in California. So rather than do what would be, I think, unwise, a piecemeal change to MCLE requirement, we would be looking to be a bit more comprehensive in doing that. And so that one would probably take, I don't think we could do that one in 6 months. I think we're talking more like 8 or 9 months to consider that. There also could be the consideration of different places in the law where we have to make changes, not just the state bar rules, maybe the rule of court itself. I don't think we'd have to deal with the statute, but we'd have to look and see. So that is the sort of overview of the timeline. I think we can turn this around. I don't want to give you false expectations, though.
Thank you, Randy. Any questions from the trustees? Any other, Eileen?
I just want to say thank you for this important work. I was really struck by how the report drew connections between incivility and bias in the workplace, and especially the retention of women and attorneys of color in the profession. I think I'm the only woman attorney member of the board right now here at this meeting, and I can speak from personal experience what a corrosive effect Incivility has. I think it's important to note it's not just, being nice to each other. It really does affect people's advancement and retention in the profession. So I think it's really important that we're taking a hard look at this. I would urge State Bar staff, when you're looking at MCLE requirements, to think about whether the State Bar could, together with the Judicial Council or with the judges on the task force, to come up with that MCLE programming. Because unlike CLE requirements that are on substantive legal topics, where we can trust law firms to come up with their own, programming on it and feel like they're representing it correctly, I will tell you that, one person's incivility is that same person is another person's, zealous advocacy. And I can think of numerous instances where opposing counsel has been uncivil to me or to my colleagues. And if you ask them, they would just be like, well, I'm being a zealous advocate for my client. So I think it would really help to have examples and perhaps examples communicated by members of the judiciary for it to really stick.
Thank you, Eileen. I think that's an important point. Anyone else? Mr. Saleg.
So, well, my thanks also to this group. I mean, it's a great work product. It's an important topic. My substantive thought is on the third recommendation. Well, actually, pardon me, the second recommendation, and I'm looking at page 4, because they're stated there at the end of the item, and then there's a resolution which is worded a little bit differently. So I have 2 comments about the direction to COPRAC. The first is I think there's really 2 tasks that are sort of mixed together. We might want to separate them. One is to review the recommendations about an amendment to the rules of professional conduct. The second is to clarify that civility is not inconsistent with zealous representation. That latter charge, I think, could be carried out in ways other than simply an amendment to the rule, such as an ethics opinion, or there's other things COPAC has done in the past, like other kinds of written work product. So we might want to kind of split these 2 things off. And then with regard to the rule proposal, I may have misread this, but when I initially read 2 as it's drafted, I thought it was a direction from the board that COPRAC shall draft this rule and propose it. I think that's not the intention by review, but I would maybe change it to consider. We want COPRAC, if I'm reading this correctly, we want COPRAC to consider this proposal. We're not saying you must draft a rule around this. And the reason I say that is, and this won't be a surprise to any members of the, we have so many groups, it's a task force, that there's going to be some fairly challenging definitional issues with that rule and some constitutional issues. And so I just want to be clear that we want COPRAC to look at all of that as a package and not say, you must present us with a rule, because if they look at it and say, we can't define this, or we can't define it in a way that will pass First Amendment scrutiny, then they need to be free to come back and tell us that if that's their considered opinion. So those are my thoughts.
Thank you, Sean. Any reaction to what Sean has suggested? Sean, do you want to take a crack at, because what I think I hear you describing is on the further resolve, breaking up a section and adding one, and then changing the language with respect to the charge to COPRAC, the request of COPRAC?
Why don't we could do 2 things, Louise. So maybe make item 2, just say COPRAC is asked to clarify that civility is not inconsistent with zealous representation, period. And then make a new item 3.
So 2, COPAC is asked to clarify that
civility is not inconsistent with zealous representation.
of a client.
Sure. That's a good change.
And then 3.
And then there'll be a new 3, which is most of what's now paragraph 2. So strike the, change review to consider in the first sentence.
Staff will review the proposal to COPAC is asked to clarify that civility is not inconsistent with zone's representation of a client.
Oh, you might be in the resolution. I was looking at the.
I'm sorry.
That's okay.
Yeah, so for those of you on the screen, I think what we'll do, and Justice Curry and Ms. Rosing, certainly, please feel free to jump in with questions or commentary if you feel there's need to clarify anything. But what Trustee Saleg is doing with the secretary right now is taking the language that's in the staff report and attempting to revise the resolution. And I think probably we should just open up the resolution once they've made those changes to give you an opportunity to look at it. So thank you for your patience. And if you want to say something, please feel free.
I would say two things. First of all, in terms of timing, if when the ball drops in Times Square, we have completed these tasks, I will be thrilled. And I think that is enough time, but it's, I understand it's a lot of work. So I think that the timing that we're talking about is just terrific. And then with respect to the directions to COPRAC, we were quite clear that they have a tough job to do because there will not be unanimous agreement in the profession about any rule change around this area. There will be lots of concerns raised, constitutional concerns about misuse of the rule. They've been raised to us. We understand them, but we think that it's important to have a rule, and that the direction should be to come forward with a rule that addresses civility in the respect that we're talking about, put it out for public comment, and let's get into it and see if we can come up with the best possible rule that protects the profession and the people of the state of California, best serves everyone's interest.
Thank you, sir.
Yeah, I was going to say that as well. And I know, Louisa, you're making Sean's edits, but I just personally, we had a recent example of a directive to COPRAC with respect to the Client Trust Account Protection Program rules that you're going to hear about later this afternoon. It was a directive to develop a rule, not a request that it be considered. COPRAC expressed their disagreement from both a policy perspective with this rule proposal, as well as raise constitutional issues. And yet we still have a staff recommendation today to go forward with the rule. So I personally believe it would be more appropriate for us to direct COPRAC to draft a rule rather than to consider the rule. And we have precedent for that, again, with respect to an item on the board's agenda today.
It certainly does strike me as within the policymaking purview of the board, right? Vis-a-vis COPRAC, as Leah has just described, they can certainly raise their issues and objections, and then we can act accordingly. Sean, did you catch what Leah just talked about?
Yeah, let me speak to that if I may. So I appreciate that. I personally don't think the board is teed up to make that policy decision today. I mean, there isn't, unless I missed it, and I've been a little hairy this week. I mean, we haven't really had a discussion about the definitional issues. We haven't had a discussion about the constitutional issues. There hasn't been a presentation about those issues in depth. So I'm not trying to nix this proposal. I just don't think we're ready to make that decision on an informed basis. So, if someone wants to propose changing it to COPRAC should come back, they should come back with their best attempt at a rule and with the pros and cons or something. I'm okay with that, but I think it would be premature for the board to direct that rule as though we've already made that policy decision, because I think we're not there yet.
And Mr. Chair, I think to that point, we could in the resolution say that we're not taking a position one way or the other at this point, but we're directing COPRAC to draft a rule with various policy considerations in mind to be reported back to the board, so the board can weigh those the various pros and cons.
Yeah, I'm okay with that. In other words, they should take their best attempt at writing a constitutional rule, but we're not, at least for me, I don't think we should commit to adopting that rule now until we really have a robust discussion about it.
I think certainly there's, past decisions that we've made that have been consistent with that approach. So I would support
improvement.
a resolution, kind of a wordsmith resolution to that effect.
Yeah. Why don't we put it up? Louisa, would you put it on the screen, please?
And to that end, Mr. Chair, what would be I'm just trying to understand, playing the devil's advocate, what would be the flip side of this conversation in terms of proceeding with a policy discussion today, or in terms of directing the amendment? I got a little confused in the discussion. So if you could help me navigate, that'd be great.
Sure. So where I think we are is there's certainly been quite a bit of legwork put in at the task force level, right? And Justice Curry's group and Ms. Rosings and Mr. Stallings has come to the point where they perceive, okay, that this is time to put it in the board's lap, not for final action today by the board, but for directive action to COPRAC, to our staff, to explore the three proposals that they have. So to me, it's a little bit of a hybrid. I think that in acting today, we are sort of embracing a policy choice that this is indeed an important issue in the profession. And as Justice Curry has pointed out, it can, and Hylin has pointed out, it can be corrosive in attorneys and their ability to stay lawyers and be successful lawyers at law firms, for example. And so we're directing COPRAC to come up with some formulations of rules, among other things. To me, it's a hybrid. I think that we are making a policy decision. If this is important, let's have the staff work on it. Let's delegate to COPRAC some more work on their part with their specific expertise. It'll all come back to the board. It'll go out to the public for public comment. I'm not sure if that answers your question, but I feel like this is, let's kick it back. Let's kick it off, rather.
Okay, that was kind of my understanding. And so I wasn't quite sure where Mr. Soleil was going, because when I begin to think about our mission and I begin to think about things around access and equity, this is in complete alignment. So I felt comfortable moving forward. So I just wanted to get clarity in terms of our actions.
And just because I forgot the MCLA portion of it doesn't mean that I'm not aware of it and don't agree that it's also important. So.
Mr. Chair, let me just also underscore the point that you tacked on to your comments that the resolution incorporates the action plan described above, and the action plan is for staff to work up public comment proposals. And the public comment proposals are not a fait accompli in terms of any board decision to make any changes in law or policy. They really are, as you say, to kick off the exploration. And the hybrid nature of what we're doing in terms of the policy side is that this will be a substantial commitment of state bar staff resources, time, effort, et cetera. And I think it is a statement that this is worthwhile. It's consistent with the efforts of the past, that the adoption of the California Civility Guidelines, the original changes to the rule of court for the oath, all these things that the State Bar has done, the new attorney training program that includes as part of its curriculum civility. So I think it is continuing in that sort of policy mode, but the specific action in terms of the plan described in the agenda item is to come back with public comment proposals on each of these. And the board retains full authority to proceed in whatever direction it chooses to at that juncture. It is really a public comment proposal that is being requested by this plan.
So to that end, I would like to move forward with adopting the resolution as stated. And
Okay, so we'll take that as a motion. I did not hear a motion on the amendments. So Ms. Shelby has made a motion to approve the agenda item as presented by staff. If there's a second, we can then further discuss. If there's not a second, then I guess Mr. Stalling, Mr. Soleg.
I'll second.
Okay, thank you. So discussion on the motion then as the maker?
Which is not the motion on the screen.
No, exactly. It's the motion as presented in the staff report originally, not the amended motion from Mr. Soleg.
I don't think it requires any discussion. I'd like to just call a vote.
Oh, I don't need to repeat what I've already said, so that's fine.
All right. I had a point that I wanted to, Mr. DeFrantorum, I think that you've just very beautifully proved to me the value of having somebody with your tenure at the bar and your breadth of experience in sort of making it clear for the board what's in front of us. So thank you. With that, we'll have a vote, please.
I have a question first.
Oh, sorry, Mark, I didn't see you. Mr.
Yeah,
Broughton.
I'm kind of wondering what we're voting on. We're voting on the original one, which is not the blue line version that I'm looking at here on my screen, correct?
That is correct. If I could ask the secretary to reject all the changes so that what you're going to be left with is the original.
So I guess if you did not vote in favor of this, would you then move to that blue line version that Sean put up there? Or is it
Yes,
just,
well, Mr. Broughton, not yet, because that actually hasn't been put forth as a motion. Mr. Slegg was working with the secretary on some potential alternatives for, I think, what would have been another motion, but Trustee Shelby's motion is on the floor, which is to adopt the resolutions as presented by staff.
Mr. Chair, point of procedure. I won't make a motion to amend just for simplicity.
Is your mic on?
I think so.
Yeah, okay.
So just for simplicity, I won't make a motion to amend, but I'm going to vote no on this because I think the amendment is preferable. And so if others who agree with me can do the same, and then I will move the amended language.
that was my question. Thanks, Sean.
Okay, I think that's clear. Great. Could we have the roll call, please?
Broughton,
No.
Chen,
Yes.
Cisneros,
Yes.
Dela Cruz,
Yes.
Delenn, Stalag,
No.
Shelby,
Aye.
Soul,
Aye.
Stallings,
Yes.
Tony,
Aye.
the motion carries.
Okay, thank you all for a very good debate. Again, thank you, Justice Curry, Ms. Rosing, Mr. Stallings, for all the good work. We look forward to what happens over the next 6 to 9 months, apparently.
Thank you so much, and we look forward to working with you as a partner on this. Thank you.
Okay. That will take us back up in the agenda to the executive director's report.
Great. I have really brief remarks today. I just want to recognize that it's at this board meeting that the board will be adopting a new 5-year strategic plan. And that's really monumental. It's not going to happen today. It should happen tomorrow. But I wanted to highlight a couple of instances that demonstrate some of the values that underlie that strategic plan. So the first one is transparency. We have that listed prominently in goal 4 of your new strategic plan. And I think about transparency and how that has played out in our recent data breach. Of course, later this afternoon or perhaps tomorrow, you're going to hear a detailed overview of the data breach. I'm not going to go into that here, but what I am going to tell the board is that our actions collectively as a team of staff have been guided by that value of transparency. And I think it has served us well. It's a terribly difficult situation for any organization to find itself in, but we have led with taking accountability, responsibility, and being transparent. And I want to thank the board for its emphasis on this value because it has bolstered our own here as staff. Another value that you see reflected in the strategic plan is effectiveness. Do we care how effective we are? It's not just about processing widgets, it's about doing it well. And this too is reflected very clearly in your new strategic plan. And I hearken back to the presentation we had earlier today on the probation reform. This is really important work. The board has been talking about recidivism in fits and starts for my entire tenure. But we end up spending the vast majority of our time focused on the backlog and on processing complaints. What that means necessarily is we don't step back and take a look at what is coming in the door and why. When you have high recidivism rates, you drive that workload in the Office of the Chief Trial Counsel. If all we focus on is processing cases and not figuring out why they're coming in the door in the first instance, we aren't an effective system. So that work you saw today on building a risk assessment tool, I know the risk assessment tools are controversial, but the fact of the matter is this is us finally putting front and center the idea of being effective in our discipline system. So those are kind of 2 examples of current issues at the bar that I think reflect these values that are embedded in the new strategic plan. And again, just my recognition and appreciation for the board because you're taking us in the right direction. So thank you.
Thank you, Ms. Wilson. Any questions for the executive director on her report? Okay. Seeing none, that should take us to the consent calendar, items 50-1 through 54-142. Does any member of the board have any questions on any of those items or seek to pull one for discussion? Mr. Tony?
Yes, I would like to pull items 50-3 legislative priorities and item 54-141 finance report.
Okay, is that for both for discussion or can?
Both
or
for
just a question?
discussion.
Okay. All right. Can I get a motion on the rest of the consent calendar? That is 50. Mr. Cardona may have modified an item on the consent calendar. That is 54-122, proposed amendment to rule -5.21 on the limitations period. So we will pull that as well. 54-122. Okay, so the consent calendar minus 50-3, 54-122, and 54-141. May I have a motion?
Sure, I'll move the remainder.
Thank you, trustee Cisneros. Second by Stallings. May I have a roll call vote, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz.
Yes.
Delenn, Stalag,
Yes.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. Item 50-3 is the approval of the 2022 legislative priorities. Mr. Tony,
There were revisions made in exec committee, right?
there were.
Yeah.
And I have.
And they will be distributed forthwith.
I want to start off by saying that I think it's important for the legislative priorities to be a discussion for the entire board. I think it's fine for the executive board, the executive committee, to have spent as much time with it as they chose to do so. But I think that it's important that the entire board be engaged in the conversation. So I am going to request that we go through this so that the full board can have a discussion, and those of us that have questions on particular legislative priorities can ask those questions.
Okay. Thank you, sir. If we could have a brief report by Ms. Herskowitz and Ms. Grammy.
Certainly. Good afternoon, Mr. Chair and members. Recognizing that I believe Ms. Grammy and I were the reason that the board got so late on their schedule today. I want to present this in the most efficient way possible. Again, I will point you to the fact that we did put a significant amount of detail into the written agenda item, and I would commend you to take a look at that. I will highlight for you briefly the legislative priorities that we have asked the board to consider. And then I think probably the best use of our time would be to turn it over to questions. Today we've got 8 affirmative proposals for the board's consideration as ledge priorities and 1 piece of legislation on which we're recommending a support position. In the category of the annual attorney licensing fee, we are requesting the board to adopt as a legislative priority the inclusion in the annual licensing fee legislation of an annual inflationary increase to the fee. It has been the bar's history to not get fee increases on a regular basis. In 2020, we got the first fee increase in more than 20 years, even though prices had gone up significantly over that period. So we are requesting, especially in this time of likely inflationary increase, that the annual fees be increased by the consumer price index in order to enable us to cover naturally growing costs. The second request for adoption of a legislative priority regarding the annual licensing fees is to increase the fee such that we can have some additional money. Less than $500,000 is what we're seeking ultimately, but a fee increase of somewhere between $1 and $3 for attorneys to support the bar's diversity, equity, and inclusion activities that were submitted to the legislature as part of our biennial plan last year. We then have three legislative priorities that we're asking the board to adopt with regard to the discipline system. Ms. Grammy, if you would address those.
Sure, I'll just go through those briefly and then you can ask questions if you have them. The first one has to do with amending the vehicle code to grant the bar OCTC investigators access to DMV photos. That would just assist in helping with the investigations. The second one is amending section 6007 C2 of the Business and Professions Code to enhance the bar's ability to protect the public from substantial risk of harm. That would be upon a finding where an attorney has caused or is causing substantial risk of harm to the public, and there's a reasonable probability that the attorney would be subject to at least a 12-month suspension. That is a change from the existing law, which would require OCTC to show reasonable probability that the attorney would be disbarred. So this would give OCTC additional authority to temporarily suspend an attorney's license or put them on involuntary inactive enrollment while the investigation and disciplinary proceedings are pending. And then the third one under this section on the discipline is it has to do with the Client Trust Account Protection Program, and it would be the statutory implementation of the recommendations from the Special Case Audit Committee regarding requiring banks to report to the bar every trust account that they are holding that's held by a California licensed lawyer. Require attorneys to engage a CPA to conduct compliance review of their client trust accounts, and also permit the bar to conduct audits of attorney-client trust accounts to ensure that they're compliant. Those are the three discipline-related items.
The next two legislative priorities reflect our efforts to improve access to justice and access to legal services for low-income Californians. Both of the priorities reflect attempts to shrink the justice gap by improving recruitment and retention in legal services. The first one, under the heading of strategic funding for legal services, would take the $5 contribution for legal services that was geared toward the funding grants for funding provisionally licensed lawyers hired by legal services organization. And that $5 was set to sunset. The legislature has proposed rolling that in with the remaining $40 contribution that goes toward legal services. A coalition of folks from the legal services community, State Bar, Legal Services Trust Fund Commission, California Change Lawyers, Access to Justice Commission, and the Legal Aid Association of California got together to brainstorm what might be a particularly meaningful use of that $5, which is about $750,000, $800,000 total, and unanimously agreed that that the most meaningful use of those funds would be geared toward funding summer internships for summer law clerk programs to help with recruitment into the public interest sector. The second proposal under access to justice is adoption of a loan repayment assistance program, which is also geared to increase recruitment and retention in legal services. We have again been working with a coalition from the Legal Services Trust Fund Commission, the Council on Access to Fairness, the Access to Justice Commission, and the Legal Aid Association of California. We have come up with proposals that would essentially give students funding to pay back their loans, and then you essentially make a loan to the student, to the borrower, to use to pay off their student, to pay back their student loan, and then you forgive the loan that you've given to the student. That's the proposal that we're looking at right now. We're working also with the, I'm in communication with the California Student Aid Commission, because there is a statutory program right now that has never, they don't have regulations, hadn't previously been funded for public interest loan forgiveness. And we're trying to ascertain the best way to administer this new program that we think is a critical tool for increasing both recruitment and retention of attorneys in legal aid. And the final legislative priority is just some cleanup language with regard to the authorizing statutes for the lawyer assistance program, which would clarify that the statutorily required outreach efforts include not only providing education about substance use and mental health, but would also authorize us to use the lawyer assistance program funding for outreach about other behavioral health or wellness issues, process addictions and the like. So that's the final legislative priority. And we're also asking the board to authorize a position on legislation. I'll again turn back to Ms. Grammy for that.
Thanks. Yes, we are asking the board to take a support position on AB 1733 Quirk, which would enable the board to, it amends the Bagley-Keene Act to allow boards to continue having Zoom meetings and allowing the public to participate that way. This board has seen a significant increase in public participation and reduced costs. And so we do recommend that the board take a support position on that bill.
And so that represents the 10 first 10 resolutions on the list. The remaining two resolutions are request to delegate authority to staff in consultation with the board's legislative liaisons to take these priorities through the next steps, i.e. further research, further development, working with stakeholders as appropriate, and including working with the legislature. Also authorizing staff in consultation with the board's legislative liaisons to take action on pending legislation in between board meetings, so long as it's consistent with the BAR strategic plan, and so long as we bring those all of the information back to the board at the subsequent meeting to inform the board of the positions that have been taken. And with that, I think the best thing we can do is answer your questions.
Thank you very much. Mr. Tony, any questions or any other trustee?
I'm happy to start. Tell me a little bit more about the issue about amending the vehicle code to authorize investigators in OCTC to access DMV photos. Can you tell me a little bit more about what that means?
Sure. So OCTC used to have access to these photos and they would use them in the investigation process. It's very typical in law enforcement.
Okay.
At some point, we lost access to that because the DMV changed their, I guess, requirements, and they don't consider the BAR a law enforcement agency because we don't have sworn investigators. And so there have been other regulatory boards like the Bureau of Automotive Repair and the Department of Real Estate that have since gone to the legislature and had their own specific amendments so that they do have access. So we're just looking to do the same thing.
Thank you. That was very clear. Thank you. Number 5, I'm really not sure about this. How you would know that an attorney will be subject to an actual suspension of 12 months or more? Like, how do you predict the future like that? I just don't quite get it.
Certainly. So the Office of Chief Trial Counsel they rely heavily on the discipline standards and case law from the state bar court that gives them a history of what is the acceptable range of discipline in a particular case based on particular circumstances. And the standards lay out, for example, I'm not going to give you a real example because I don't, because I'm going to say something incorrect.
No.
But with a particular case of misconduct, the standard may say that the appropriate discipline is actual suspension to disbarment. It's a range, and then using the history of decisions in the state bar court, the Office of Chief Trial Counsel has, every time they seek discipline, they actually provide to the court based on this case law that you've established, this is the discipline that's appropriate in this case. But I think what's incredibly important to understand in this instance is this is not OCTC sitting in their own closed four-wall office saying, I think that there's a reasonable likelihood that you're going to have a suspension of 12 months or more. Therefore, I'm putting you on involuntary inactive. That is not what happens. The Office of Chief Trial Counsel, after conducting an investigation and developing evidence, would file a motion in the state bar court, and the state bar court would ultimately be the arbiter to say, yes, we believe that there is a reasonable probability in this case, and this is a case in which an attorney, there is a substantial risk of the attorney committing harm to their client or clients, that we believe in this instance, there is a reasonable probability that the person will be found, based on the evidence you've presented today, culpable of misconduct that would result in discipline of 12 months or more. And then the state bar court would say, based on that finding, we therefore are going to order the involuntary inactive status for this client. So I think it's really important to understand the due process that's around this. And it's not just OCTC sort of flipping through a book and deciding.
So it's going to a judge, even
Yes.
though it's a state, it's still
Yes.
going to an independent judge. It makes it sound like almost like the concept of like a temporary restraining order or that kind of thing where there's a danger of harm, even though it hasn't been proved or litigated, and to protect the public, if you will. That's why you're getting a third party to decide this is probably a good thing for now.
That is a fantastic example, except I would say that this requires substantially more evidence than
Oh,
that TRO might
Okay,
require.
well, that's good to know.
But otherwise, that is a spot on, right example.
I'm just trying to understand the concept.
And it's just to expand on that, OCTC does have that authority now, but only in very difficult cases where you can show disbarment. So we're trying to expand that authority a little bit, but this is still for very extreme cases. You know, right now, we said from 2017 to the present, they've used this, they've requested this remedy 11 times. And we're thinking, they estimate maybe it would be double that, but we're not talking about hundreds of cases.
Very useful. Thank you very much. That's my questions. I just would like to ask the chair to consider in the future of, I believe it's important that legislative discussions and actions not be placed on consent agendas. I think they're too important. I think the full board needs to discuss it. I appreciate the work of the legislative committee and the work they do to prepare for it. I think it is up to the executive committee to determine how much they want to discuss, but this is an issue where the executive committee's discussion should not supplant the board's responsibility of being on top of it. So that's a request I will make for your consideration in the future. You should expect me that anytime it's on consent, I will ask for it to be taken off consent.
Okay, thank you, trustee Tony. Any other questions on the legislative priorities agenda item? Seeing none, I will entertain a motion to approve, please.
I'll make the motion.
Trustee Stallings with the first,
I'll second.
trustee De La Cruz with a second. May I have the roll call, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz,
Yes.
Delan, Salag,
Yes.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. I am we've got two more items pulled from consent, and we'll go through those, and then we may have to take up another item under reconsideration from the consent calendar because I believe there was a change to one of the resolutions that did not make it to our attention. So next is 54-122. And I don't have my agenda up. Here we go. This is this is the one that we made changes to at the Regulation and Discipline Committee. Mr. Cardona, if you could just stand by in case there are any questions. And are there any, Mr. Tony, you pulled this for question or discussion? No, you did not. I apologize. This was simply for the fact that we made changes. So on the screen, you see the change as a result of the consideration of the RAD committee, which is essentially provided that subdivision G will remain unchanged with respect to attachment A, effective as of April 4th, 2022. Any questions from the trustees or discussion on this amended recommendation?
Chair, I'll move it.
Motion by Stallings,
Second.
second by Cisneros. May I have the roll call, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Delenn, Stalag,
Yes.
Shelby, Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. Next up is 54-141, the approval of the financial statements report, investment report, and client security fund report for the 9 months ending September 30th, 2021. Mr. Tony, you pulled this for a question or discussion?
For discussion. I think it's, I serve on the finance committee, so I'm very familiar with this and I am supportive of it, okay? The issue is, I think part of the fiduciary responsibility of the Board of Trustees is to review the financial report at every meeting. And putting on consent simply does not permit that to happen. So I would ask that our CFO, Montoya Chico, give a presentation and at least at the very top line, review this, and that the Board of Trustees has an independent vote after having reviewed the financial report.
Okay. I'll have a comment on that after the report from Ms. Montoya Chico.
Okay, so earlier today, I presented to the Finance Committee the financial statement highlights for our quarterly report. So I'm going to show a couple of slides to help visualize the numbers and my explanation. So please let me know once you see my screen.
Your screen is up.
Great. Okay, can you guys see my presentation now?
Yep.
Great. So as I mentioned earlier today, I presented the financial statement summaries to the Finance Committee. So I'll briefly summarize really our budget versus actual results for the 9 months ended September 30th, 2021. And I'll first get into our revenues followed by our expenses. So in this first slide, we have, you can see our total operating revenues for the period are above, are slightly below budget by about $12.5 million. And this is presented at the fund level. So I'll go into the detail of those funds that had the most significant changes. So in the revenues, the general fund revenues are above budget by almost $3 million. And that was really mainly due to our mandatory fees in the general fund that we under budgeted as of the period end. The next line item here is what I call the grants funds. So that includes the Legal Services Trust Fund, the Equal Access Fund, and the Homeless Prevention 2 grant fund. And these are all, as I mentioned, the grants fund, and those are all significantly below revenue, close to $17 million. And that's really all driven by the allocation of revenues, as most of these are multi-year grants. And the main reason for that variance is that the way we budgeted didn't align with how we accounted for these grants. So that's why you see that significant variance. And last October, we actually had a budget amendment. So this should self-correct by the end of the year. So there will be this significant variance you see right now shouldn't reoccur in Q4 and going forward. And the admissions fund revenues are slightly above revenue by about $1 million. And that's really driven by two main factors. One is the exam fees and the other is the moral character fees. The exam fees were higher as we had a broader pool of applicants since the exam was fully online in all of 2021. Similar case for the moral character fees. Because the exam was online, we were able to get a broader pool of applicants. And we also additionally reduced the passing score. So that helped us with additional revenues from more applicants. Now moving on really quickly to the expenses, our budget versus actual on the expenses. You will see that our total operating expenses are below budget by close to $6 million. And first off, with the general fund, most of the savings in the general fund expenses were due to our personnel savings resulting from staff vacancies. And those savings were slightly offset by an increase in our building improvement expenditures that we did not budget in 2021. Now, on the equal access and the equal access expenses, those were higher by about $6.4 million from budget. And that's due to two factors. One, we had 2020 expenses that were paid in 2021. And this is all due to the delay in the judicial council funding. That contract was not signed until well into 2021. And then also we had 2020 unused homeless prevention 1 grant. We have various homeless prevention grants. We had 2020 homeless prevention 1 grant funds that were returned by grantees, and we were able to redistribute them in 2021 to other grantees. For the legal services trust expenses, they were higher, slightly higher by close to $500,000 than budget. And this is really mainly driven by the provisionally licensed lawyers program that we did not budget in 2021. Moving on to the admissions fund, as I mentioned on the revenue side, we also had savings on the admission fund expenses due to the exam, primarily the exam expenses, but also some personnel cost savings. Given that the exam was in a remote format, we were able to save on some of our expenses we typically do when we had it online versus in person. And we also had close to $1 million in personnel savings from staff vacancies in the admissions fund. And then finally, the client security fund is below budget on the expenses of about $1.7 million. And this is really just mainly due to less payments that we made as fewer applications were processed than we had anticipated. So I'll stop sharing, and that's a summary of where we are financially for our revenues and expenses, budget to actual, if anybody has any questions.
Thank you very much. Any questions for Ms. Montoya Chico? Okay, Mr. Tony.
I understand that last year was a year of transition with you coming in late in the year as CFO. In future years, should the board expect at its March meeting to have a financial report for the entire fiscal year ending December 31st? Would that be a reasonable expectation?
Yes, the goal and my goal is to be able to present the quarterly financial statements in whichever is the board meeting after that quarter close. So I know right now we're a little bit behind, but my goal is to fully catch up, especially in 2022 now that we started a new fiscal year.
Thank you.
Yeah.
Thank you, Trustee Tony. Any other questions? So before we take up a motion on this, I do want to just, I want to be careful with, I don't think that you were suggesting this, but it certainly could be implied or understood that the inclusion of an item on our consent calendar doesn't mean that it's not considered by the board as we're preparing for our board meeting, or that it's not available to the public for their consumption. There's a lot of value. I don't disagree with you. A lot of value in having these numbers presented to the board in the way that we just had it. But certainly as things get more and more regular, if it's on the consent calendar, it's fine for me. Any member of the Board of Trustees obviously has a right to pull any item for discussion or question. I just wanted to be clear that consent calendar items technically are considered by the board. They are available to the public for an inspection and question. And when we vote on it, it's an approval.
And I just would like to say that in my review of consent items, I think far too many items are on consent. And truthfully, there would have been other items I would have asked to be moved for discussion for the whole board. I really think that consent means that it's something that's non-controversial, that there isn't a lot of discussion that is anticipated. And it may be the kind of thing where board members can be polled before an agenda is constructed for, are there any of these items that we're thinking about putting on consent that you'd like to be on the regular agenda, so that it helps with planning and the timing of meetings by knowing how many agenda items board members would like to discuss. So part of the issue is that I get these agendas and there's a whole lot of stuff on the consent. I try to signal, through informal conversations that there's certain issues I'd like to be taken off. And, I'm just saying, maybe there's another way to do it.
Thank you, sir. Okay, any other comments or questions? We have a motion on item 54-122, please. 141, excuse me.
So moved.
Thank you.
This is Arnie, I'll second.
Thank you, trustee Sewell. May I have the roll call?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
Yes.
Delenn, Saleg,
Yes.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. At this time, I'd like to ask a member of the board for a motion to reconsider item 50-4, which was the rules of procedure to continue to conduct state bar court proceedings remotely. The reason for that request is that there was a change to the resolution, which is not reflected in the item as presented on the consent calendar. And so because we've already voted on it, it needs to be brought back up for reconsideration, and then we can vote on it after we've highlighted what the changes.
This was a change to the resolution made upon your request, trustee Tony. So we'll put it up on the screen.
You need a motion for reconsideration.
I do, please.
So moved.
Second.
Move to reconsider 50.4. Can you have the roll call, please?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz,
No, this is just the motion to
Oh,
reconsider.
Got it. Yes.
Delenn, Saleg,
Abstain.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
So these amendments, trustee Tony had asked that there be a little bit of explanation added to the resolutions rather than just reference to the rule numbers. So that's what these modifications do.
Thank you for putting them up on the screen. I think that they are very clear and make a lot of sense. Thank you for the suggestion, trustee Tony. Any questions or commentary on the revised resolution? Seeing none, may I have a motion?
So moved.
Thank you, Mr. Tony.
Second.
Thank you, Cisneros. Can we get the vote on that revised motion?
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Delenn, Saleg,
Abstain.
Shelby,
Aye.
Sol,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Okay, that takes us to item 701, which is the approval of the exception to the CalPERS 180-day wait period and waiver of the Board of Trustees Policy Manual 12-month wait period for the appointment of Mr. Dag MacLeod as retired annuitant under Government Code Section 21-224. Ms. Holton.
Jean Krasilnikoff from the Office of General Counsel is going to present them. She's made arrangements to be.
Yeah,
promoted,
just
and
given
we're
the
gonna do all
time, do
three
we need
together.
to present them?
Yeah, as a matter of fact, with the board's permission, I'd like to take up 701, 702, and 703 as one consideration. We can get one staff report, one very brief staff report. And if anybody has questions, we can get into it then.
Okay.
Sure, I'll make that motion.
Do you have Jean?
I'm here, Vanessa.
All right.
Good afternoon, everyone. I will make this very, very brief. The three items under consideration today relate to appointing three former employees as retired annuitants. CalPERS normally requires a 180-day waiting period between an employee's retirement date and his or her return to work as a retired annuitant. The board may approve an exception to that waiting period where there's a critical need for the individual's skills within that 180-day period. And we are seeking an exception for Mr. MacLeod, Ms. Katz, and Ms. Cohen, so they can be appointed as retired annuitants during the 180 days following their retirement dates. Additionally, for Mr. MacLeod, we are seeking a waiver for good cause of the state bar's policy restricting business with the state bar after leaving office, which normally prohibits senior managers from doing business with the state bar in the 12 months after they leave office. And the details regarding Mr. MacLeod, Ms. Katz, and Ms. Cohen's background and qualifications are outlined in the agenda items, as are the items they will be working on as retired annuitants.
Thank you, Ms. Krasnikoff. It's very important that we put all of this in the record and that the Board of Trustees understands that these CalPERS rules are very strictly enforced. There does need to be a bona fide need for these retired annuitants to return much more quickly than the law allows. The item that's in your staff report, I think, lays it out very nicely, and I think that we've all benefited from the good work of the three individuals that are the subject of these actions. But I do want just to reinforce that. Ms. Wilson, do you have anything to add?
No, I don't.
Any questions or comments? Seeing none, may I have a motion on 701, 702, and 703?
Mr. Chair, I'll make that motion.
Motion by Stallings.
I'll second.
Second de la Cruz. Roll call, please.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
de la Cruz,
Yes.
Delenn, Saleg,
Yes.
Shelby,
Aye.
So,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. Look forward to working with these folks again in this limited capacity. Item 704, we've already taken up and acted on. Item 705 is a discussion and debate on, discussion and update. Wow, was that Freudian or what? On Client Trust Account Protection Program and request to circulate it for public comment. Ms. Wilson,
Yes, and it
please.
says Wilson and Lyles, but the plan is to have Randy and Kelsey do the presentation. I will just introduce the item saying that we're bringing forward both a status update and a request for action by the board to advance the proposal. So not sure who's starting us off. Is it Kelsey or Randy?
I will start us off. Hello, everyone. My name is Kelsey Lyles. I am a principal analyst in Oriya, and I'll be co-presenting this update with Randy. I'm just sharing my screen. One moment, please. Wonderful. So this past November, the Committee on Special Discipline Case Audit presented its final report and recommendations for implementation of the Client Trust Account Protection Program to the Board of Trustees. Today's update will discuss progress on CTAP implementation activities, proposed changes to the CTAP timeline and design, and also 3 rules that are issued for public comment to support implementation of the CTAP. Regarding the timeline, this slide outlines the initial timeline that was included in the final report to the board. There are 2 main reasons why we are proposing an extension of this timeline. First, since submission of that final committee report, staff determined that an implementation rule, which is needed to grant the State Bar authority to require the self-reporting from licensees, must be fully in place prior to the initiation of the mandated registration of client trust accounts, as well as the annual self-assessments by those attorneys that have client trust accounts. Secondly, there are some cost constraints to consider. The State Bar General Fund cannot currently sustain the entirety of the implementation costs without a license fee increase. So due to those reasons, we are proposing an extended project timeline. Regarding budget, the current 2022 State Bar budget does include a seed funding for the CTAP of approximately $250,000. And we are anticipating that that money can be used to support this revised set of phase 1 activities and possibly to support some of phase 2. So presently we are prioritizing working to propose the rule that will grant the State Bar the implementation authority, as well as issue those rules for public comment, process those comments, and get the rules adopted. And this will subsequently allow the State Bar to move forward with prioritizing the annual registration of client trust accounts, annual certification of compliance with the rules, and also the annual self-assessment for attorneys that are operating client trust accounts. So this slide really just outlines that revised timeline, which is also in the agenda item. And now I'll give a quick update on some of the progress that's been made to date. Randy will give a more thorough explanation of this new rule of court 9.8.5, but this is the proposed rule that will grant the State Bar the authority to launch the CTAP and some of the key reporting and analytical requirements. Also, a lot of progress has been made on additional phase 1 activities. For example, the annual registration of client trust accounts and certification of compliance is underway. ORIA, as well as the Office of Information Technology, have put together an example online reporting form, which will be built out and included in the current My State Bar profile, so that when licensees annually pay their dues, it's also pretty easy for them to acknowledge whether or not they have a client trust account, and if so, provide some additional information and data indicators such as the account name, financial institution, and balance. So this is really important for the State Bar to begin to understand how many licensees currently are operating client trust accounts and how much money is flowing through those accounts. And that's currently being designed with an anticipated effective date of the 2023 billing cycle. Similarly, the annual self-assessment is also underway. The Office of Professional Competence has secured a vendor, and they are working on content that can be built out for that launch as well. And also, Rules of Professional Conduct 1.15 as well as 1.4 were referred to COPRAC and discussed, and members of that committee did draft additional rules which will be considered and discussed today. Also, I'd like to share that there is a proposed addition to the CTAP design. While staff were doing research and working on implementation and learning more about the IOLTA process, it became clear that bank data would be a really important complement to this process. Through the collection, by mandatoring the collection of bank reported information, it will allow staff to verify the accuracy of the attorney's self-reported data and really help with that analysis. And it can also promote transparency and encourage the appropriate reconciliation of accounts. Some example data indicators may be account name, or like the name of the attorney that's operating the account, as well as the account number and balance, for example. And to mandate bank reporting, the State Bar is recommending amending Business and Professions Code 6091.1. And that code already requires financial institutions to report to the State Bar when trust accounts have insufficient funds. So it would be building out that. And now I'm going to turn things over to Randy to discuss the rules that are being issued for public comment.
Thank you, Kelsey. So the first rule that we have for you is a proposed new rule of court. And this rule of court will essentially serve as the authorization for the State Bar to conduct the Client Trust Account Protection Program. It will be an enabling rule. It is similar to, for example, the rule of court 9.35 that authorizes the state bar to conduct a program for certifying legal specialists. That program is enabled through a rule of court. It authorizes state bar rulemaking and states the consequences for failing to comply with the state bar rules when you're under that program. And that's exactly what 9.8.5 is intended to do. As you see on the screen, it will authorize the state bar to adopt rules and regulations for CTAP. It will provide non-exclusive examples of the requirements. And so the requirements to do the self-assessment, the requirement to annually report, the requirement to submit to an audit if you're selected. All of those things are listed, but they're not the exclusive examples. The CTAP program will have the ability to flex and grow built into it the way this rule of court is worded. It will specify that the failure to comply with these requirements will subject a lawyer to being enrolled as an inactive attorney. And so similar to the MCLE requirements, where you're given multiple opportunities to bring yourself into compliance, but if you completely fail to do your MCLE, at a certain point, you will be enrolled as an inactive licensee. It is not a disciplinary proceeding per se. It is an administrative response. And the rule of court is different from implementation, for example, by a rule of professional conduct, because there will be no explanatory comments. The rules of professional conduct provide for comments, but not the rules of court. So that is the enabling rule, rule 9.8.5. And that number 9.8.5 would fall in between existing rule of court 9.8, that is the state bar's maintenance of the role of attorneys, and rule of court 9.9 that deals with the obligation of online reporting by attorneys. Does anybody have any questions about the proposed enabling rule, rule of court 9.8.5?
All right, this is Brandon Stallings, Vice Chair, filling in for Ruben Duran. Chair recognizes Mr. Tony.
Thank you. Here's a question. It just has to do with how things are set up now. With client accounts, are there requirements of how they're set up? In other words, do attorneys set up just one client account for all their clients, or are they required to set up separate client accounts, either by individual person, or maybe if it's, a case where there are, groups of claimants, maybe one for each one? How does that work now? What are the basic rules?
Very good question. The basic rule, because we have a statutory IOLTA program in California. IOLTA stands for Interest on Legal Services Trust Accounts. And the IOLTA program specifies that lawyers should generally have a single unsegregated client trust account for all funds received and held on deposit that are nominal or on deposit for a short period of time. And the theory of that test, nominal and short period of time, reflects the concept that if you had 50 clients and you opened 50 separate trust accounts and you only held a small amount, say $1,000 for 3 weeks, then the cost of those accounts, the interest collect on those accounts probably would not even be enough to justify the creation of those accounts. But if you pooled those 50 client funds into a single account, and you used your dutiful compliance with your record-keeping obligations to make sure you know whose money belonged to who in that account, that aggregate pool of money could collect enough interest to be meaningful. And what the statutory IOLTA program does is actually collect that interest and use it to fund legal services. And so the general rule for attorneys is that they would have a single IOLTA account for all of their client monies. Again, if they're on deposit for a short period of time or a nominal amount. If you are holding an extremely high amount of money for a long period of time, then there's this idea that you could create what's referred to as a 6211B trust account under the State Bar Act, where the interest is payable to the client, because you are a fiduciary of those funds. And if the money could create interest that not only covers the cost of the maintaining the account, but also provides, a net gain for that client, then a separate account is possible for that attorney in that situation for that client. But again, as you say, the basic general rule is a single and segregated account because we are an IOLTA jurisdiction.
Thank you.
Any other questions?
Want to go forward, Randy?
Let's move on to the next rule. Next screen, please. The next rule that we're presenting for public comment authorization is an amendment to the rules of professional conduct. It is Rule of Professional Conduct 1.15, which is the rule governing a lawyer's handling of entrusted funds or property. And these provisions are intended to clarify and strengthen the lawyer's trust accounting obligations, and includes a provision that would even create a presumed violation if a lawyer did not distribute funds to a client or to another person who's entrusted those funds within 45 days of the time that the funds were basically fixed and earned by that person. And so this is a significant change from the existing rules, but it is intended to be very client protective, while also recognizing some of the realities in the practice of law. So let me start with one of the first changes. The first one, as you see listed on the screen, is that we're going to propose the replacement of the promptly notify standard with the requirement to notify a client within 14 days. If you were to go back in time to 1928 and you looked at the original rules of professional conduct, Rule 9 was the client trust accounting rule. That rule included only two provisions: do not commingle funds. And the second one was promptly report to the client the receipt of funds received for that client. And so that requirement has largely remained unchanged since the original rules of professional conduct in 1928. What is being proposed here is that you replace the concept of promptly and you use a standard that would provide, absent good cause, the lawyer has to notify the client or other person no later than 14 days of the receipt of the funds. And so that is intended to be a more prescriptive standard, but it also contains necessary flexibility for the attorney to present whatever good cause there might be for not notifying the client that funds have been received. And it's important to clarify that this is really just a report as it was originally framed back in 1928 and currently referred to as notify. And so you're not being required to give full comprehensive advice or a distribution invoice to the client within 14 days. You're required to give them notice that funds have been received. The second one is to remove the condition that a lawyer's duty to distribute funds or property is triggered only when a request is received. The current rule has been interpreted in disciplined case law to provide that the lawyer's obligation to release funds to a client is only triggered when the client asks for the money. Now, that is premised partially on the concept that you have a duty to promptly notify the client. So if you promptly notify a client that money has been received, a reasonably self-interested client would turn around, presumably, and ask for that money. And so the current rule relies on that as the trigger, again, to have the attorney's duty to promptly distribute funds. The clock starts ticking at that time. And we are recommending to go out for public comment a removal of that provision from that part of the rule. So paragraph D7 of Rule 1.15, instead of saying promptly distribute as requested by the client or other person, any undisputed funds or property, etc., it would simply state promptly distribute any undisputed funds or property to the client or other person. The third thing we're doing, and this is the one I alluded to initially, is that we're adding a presumed violation standard. And so right now, the standard is to promptly distribute the funds, and promptly is interpreted by case law. And so in order for a lawyer to decide when I actually have to release the funds, they would have to look to the case law and compare it to their actual facts and surrounding circumstances and decide that, yes, it is now time to promptly distribute these funds. If you were go to the handbook on client trust accounting, because the record-keeping requirements, the board's record-keeping standards provides for a monthly reconciliation of the client trust account. The handbook on client trust accounting provides guidance that you should consider dispersing any funds once you do a reconciliation each month that you know has cleared in terms of entitlement to a client or other person, that would be the time to distribute it. But that is not the rule. That is just the guidance given in the handbook on client trust accounting. The rule that we're recommending go out for public comment would provide that if an attorney does not distribute the funds to a client or other person to whom it's owed within 45 days, and there is no good cause for not doing so, and the client hasn't otherwise, or other person hasn't otherwise asked you to hold those funds, and the funds are not disputed, and we're adding a definition, a new paragraph G that would define disputed funds. If none of those things are present, then the lawyer would have the burden of proof shifted under the evidence code to show why the failure to distribute the funds within 45 days should not be considered a violation of their obligation under D7 to properly distribute the funds. Number 4 on the screen is the definition of undisputed funds, and it is a non-exclusive definition, but it makes clear that these issues can include a very wide range of different issues, whether it's medical liens, statutory liens, prior attorney's liens, disputes as to costs, the bank's policy for clearing the check, the fact that the client is a plaintiff in a litigated matter and has not signed the release dismissal that would perfect their entitlement to get the funds, that the attorney can't get a lien holder to agree to a release and has to file an interpleader. All of these things are built into the definition of undisputed funds to facilitate the lawyer's determination that the funds are now fixed and earned and the client's entitlement is not clouded by any thing impairing their right to receive the funds. And I need to start counting down the clock because I only have 45 days to get those funds distributed.
Randy,
Sorry.
I don't know that you need to go through in such detail every single proposed amendment. I think you've hit the
Okay.
or the 45 days and the presumed violation.
Sure.
I'm assuming you're planning to talk briefly about the concerns that COPRAC raised with respect.
Oh, yes.
Okay, maybe we can move to that and then move to the.
Certainly. So the board resolution adopted following consideration of the Special Audit Discipline Committee report asked that these concepts for revisions be provided to COPRAC, and COPRAC did get that assignment. I want to clarify that while COPRAC was assigned the drafting exercise, this was not a typical COPRAC rule revision process. The assignment to COPRAC instructed them essentially to take the board's policy decision to explore these specific amendments, and they did not draft the rule themselves from scratch. We tried to, it was a short timeline, they had 2 meetings to do this. Staff provided discussion drafts, several iterations to help them move this project along, and COPRAC's good work was in the form of reviewing, revising, and refining those drafts. And COPRAC has submitted their good work to us, but they've also submitted a memorandum, attachment C, where they detail that process and they identify some of their concerns. One of their concerns was a belief that the introduction of a presumed violation for the failure to disperse funds promptly would be subject to enforcement challenges, in particular possible constitutional challenge. Because of that concern, that we took that very serious, we did get legal advice. And upon review of that legal advice, we do not believe that challenge is one that should prevent us from going out for public comment and continuing to explore this particular revision, which is to add the presumed violation. I'll stop there and just see if there's any questions on the proposed amended rule 1.15.
Trustees, any questions on 1.15? Okay, seeing none. Mr. Saleg.
Randy, thanks. So I'm curious, the one thing that caught my attention in the COPRAC memo was the burden of proof issue. So how is that, the rule is silent on that. How is that going to be determined? So the COPRAC questioned whether the clear and convincing standard of proof would apply, which is the burden that the state bar has to meet in disciplining an attorney. And that's a very, very high burden of proof that's close to beyond a reasonable doubt in criminal cases. And so they wondered if the attorney would have that burden of proof to rebut the presumption versus a preponderance of the evidence, which is more likely than not and the most typical burden of proof.
That is an interesting question, and we will be taking time to research that thoroughly during the time that the rule is out for public comment. We have done some initial research, and there doesn't appear to be anything definitive under Evidence Code 605 or 606 that prescribes how, when the burden is shifted, the burden of proof level is determined. What we did find is that there is a statute for California that says, unless it's otherwise stated, the burden of proof will be preponderance of the evidence. But it is possible, and again, we haven't finished the research on this question. It is possible that if this does come up in a litigated situation, that the court could request briefing on the issue of the shifted burden, and that the court would decide what it would be given the particular issue or fact that was being shifted for that proof. And so short answer is we're continuing to look into it, but the preliminary research in regards to existing presumed violations, certainly within the discipline system, has not uncovered anything that definitively answers that. We don't have anything on the advertising presumed violations. I'm not aware of anything in regards to the misappropriation presumption or the State Bar Act's own presumed advertising violations, which are separate from the board's presumed violations under Rule 7.1. And so we are looking into that.
Okay. Okay, that's good, because I think I'll look forward to that. I think that's a really important issue that has to be figured out before the bar adopts this rule, because it strikes me that imposing a clear and convincing burden on the attorney has some policy issues and maybe constitutional issues. But I could see where the attorney has to rebut the presumption by a preponderance, and then it has to be figured out what the state bar's burden is. I assume it will still be clear and convincing evidence. But that's really important to sort out before this rule is actually adopted. It doesn't affect it going out for public comment.
Certainly.
Thank you.
Thank you. Any other questions on 1.15? If not, we'll move on to 1.4. Go for it, Randy. Thank you.
1.4 is very straightforward. In the Special Discipline Audit Committee's discussions, there was concern about client communication. And that is why we have the proposal to replace the promptly notify standard with a 14-day, absent good cause standard. But in addition to that, the requirement to promptly notify resides in the trust account rule. There is a separate rule that governs attorneys' communications, and that is Rule 1.4. And the requirement for that rule is that you have to communicate anything that is a significant development. But there's no mention of what might be examples of significant developments. And so what has been developed is a new comment to Rule 1.4 that would specify that a lawyer's receipt of funds is in fact a significant development, and it would include a cross-reference to Rule 1.15, paragraphs D1 and D4, because those are the provisions that deal with a lawyer's communication about trust funds. D1 is the one that requires notice that you receive one. D4 is the provision that says you have to provide a reasonable accounting. And so we think the specification in a comment that receipt of funds is a significant development, and the cross-reference to the other duties in communicating with clients about their trust funds, the reasonable accounting, will help lawyers understand that communicating with clients about the funds that have been received and what's happening with the funds, the accounting that you're going to provide to them are important. We didn't change the black letter. The duty remains the same. It is still inform the client of significant developments, respond reasonably to inquiries, et cetera. But we have made clear in a comment that receipt of funds is significant and that you need to also look at all of your trust accounting duties, including the ones related to client communication in the Rule 1.15. And that's the communication rule change.
Seems to make a lot of sense to me. Any questions? Any discussion on circulating these proposed rules for comment? Get a motion, please. Mr. Tony.
I would like to say that I'm very excited about these proposals. I think it moves the needle on the question of how do we create more protections for client trust accounts? How do we intervene before something has happened, and just create a much greater system of protections. I really want to particularly call out and thank Trustee Cisneros for his leadership on the committee that put together these resolutions, and for kind of providing not just committee leadership but thought leadership on this. I just would like to encourage staff to make sure we figure out a way. This is the kind of, I think, proposed rule that we will probably not have a lot of problem receiving robust comments from the legal profession, and I would expect that. And we need to hear from them because I'm sure many of them will have ideas on how to improve what we have. I also want to make sure that we hear and that we try to target people who have had maybe issues or problems with client trust accounts, the clients themselves, in other words. So I just want to make sure that, we may want to do, staff may want to do some targeted outreach to make sure that we get a balanced set of comments and perspectives as we consider what the right thing to do is. Thank you.
Points all very well made and well taken, Mr. Cisneros, and then Mr. Seleg.
I'd like to second Mark's comments that this is a very important initiative and move the item for adoption.
And I'll second.
Motion by Seleg, second by Cisneros. Understatement of the meeting that we're going to get a lot of comments from attorneys. I do hope we get a lot of public comment as well. So
I do want to assure the trustees that similar to the campaign we employed for the paraprofessional program working group, where we tried with intentionality to get true public comment, we're going to undertake that kind of process here.
Thank you for that. Okay, seeing no discussion, can we have the roll call, please?
Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz,
Yes.
Delan, Seleg,
Yes.
Shelby,
Aye.
So,
Aye.
Stallings,
Yes.
Tony.
Aye.
Motion carries.
Thank you, Madam Secretary. Why don't we do a 8-minute break? Come back at 4:30, please, to resume our agenda. Thank you. Okay, we are back after a short break. Thank you all for being here promptly. We're going to move to our next agenda item, which is 706, the approval of the revised charter for the Closing the Justice Working Gap. um, group, working group. Thank you. It looks like we have Ms. Grammy to present.
Hello. So this is really just a follow-up from your February item where we talked about the letters we received from the legislature having to do with concerns of the Closing the Justice Gap Working Group. And as you recall, the board had three resolutions out that came out of that meeting. So the first one was to revise the membership of the working group to limit it to just people with California specific experience. So as I detailed in the memo, we established a procedure for determining that, and we've attached the revised charter or the revised roster reflecting a streamlined version of the working group. The board also directed staff to revise the charter. And so we've attached as attachment C as a revised charter. We have a red line version for the original. It removes the ancillary assignments for the working group, which were to consider some additional rules, and is really just streamlining the assignment to work on a recommendation for a sandbox, a regulatory sandbox, and just makes clear specific recommendations that the board is asking the working group to come up with, basically to address some of the concerns that we've heard from the legislature and stakeholders. And then finally, the board voted to appoint liaisons to the working group. And so in the interim, Trustee Tony and Trustee Chen have agreed at the chair's request to serve as the liaisons. And so the three resolutions, I've actually added one in addition to the two that are already on the memo. But the first one would be just to approve the revised charter. The second is to appoint trustees Tony and Chen as the Board of Trustees liaisons to the working group. And then the third one, we just realized we need to extend the term of the existing working group members to May 31st, 2023, just to coincide with the extended timeline that the charter contemplates. Any questions?
Thank you, Ms. Grammy. Any questions for Ms. Grammy? Any discussion from the board? Before we take a motion, I will just sort of say in closing, we had, I think, upwards of 20 public comments at the February meeting on this, and certainly many, many written comments and a lot of discussion with stakeholders on this very important issue. So thank you to everyone who has sort of hung in there with us as we've adjusted and adapted. Leah said something a little while ago about adaptability. I think you were talking to Ms. Melcher. I can't remember who it was, but I recall when I was sworn in as the chair in September, I talked about the strength, the adaptability, and the resilience of this organization. And I think this ongoing work of this working group is very much exemplifies those ideals in action. So thank you to trustees Tony and Chen for agreeing to liaison with the rest of the work, and for folks, Justice Tucker and her very dedicated working group. Thank you for your continued efforts. Is there a motion on this, please?
I'll make the motion.
Motion by Cisneros. Second by Stallings. May we have the roll?
Broughton,
Yes.
Bureau.
Did you hear me?
Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz,
Yes.
Delan, Salag, Shelby, So,
Aye.
Stallings,
Yes.
Tony.
Aye.
Thank you,
Motion
Ms.
carries.
Thank you, Ms. Grammy. We were counting heads to make sure that we've maintained a quorum. We barely have a quorum here. So if anybody sees trustees Saleg or Shelby out in the hallway, please let them know. We would very much like their presence. We'll move on to item 707, the update on the Odyssey case management system vulnerability regarding confidential attorney discipline records. Mr. Mazur presenting on discussion only. Good afternoon, sir.
Louisa, can you put it in? Yeah, great. Okay. Good afternoon, Steve Mazur, Chief Administrative Officer. Over the last several weeks, the board has received a number of updates on the issue of non-public state bar case information being obtained by Judy Records as a result of a security vulnerability in the Odyssey case management system portal. Today, I'd like to provide just a fairly brief recap and summary of what happened and where we are now, focusing largely on the technical issues. So, pardon me. So on February 24th, we first became aware that both public and non-public state bar records were on the Judy Records site. Judy Records describes itself as a free nationwide search engine that lets you instantly search hundreds of millions of United States court cases. They claim to have over 630 million cases on their site. Immediately upon learning of this matter, the bar's leadership team immediately recognized the seriousness of this situation and made a 100% commitment to resolving it using all appropriate resources and, as Leah mentioned, with complete transparency. So on the resources side, the response team has been comprised of the executive director, the general counsel, myself, the IT director, the communications director, and many, many members of our teams. The day after we became aware of the situation, we had already engaged a third-party IT security firm with extensive IT forensic investigation experience. Shortly thereafter, we also engaged Cooley LLP to provide legal representation. Tyler Technologies, the maker of the Odyssey case management system, was, of course, engaged immediately as part of the investigation. Speaking to transparency, we have been keeping board leadership and key stakeholders informed. Also, within 48 hours of learning of the issue, we did issue a press release and an FAQ on our public website. This was the minimum time that we needed to have enough clarity about the situation to make a meaningful and accurate preliminary statement about what had happened. So now I'm just going to go over some key facts of the situation. I've sort of divided it up into a few buckets based on how the investigation has evolved over a number of weeks. So our first bucket, in the first 3 days or so, we focused on mobilizing our team and conducting a preliminary investigation. Based on our own initial review, it did appear that Judy Records had approximately 60,000 public cases, but also 260,000 non-public records. We did note that the public cases had the full case profile information as they appear on the State Bar Court Odyssey portal. The non-public cases, however, only had limited fields of information, such as the name of the parties, case number, and limited information like that in most cases. We also determined at that early stage that the Odyssey portal was likely the source of the data breach. Shortly thereafter, Tyler Technologies, the maker of Odyssey, did confirm the existence of a vulnerability in the Odyssey portal, which could allow access to non-public records. I do want to stress this was not a vulnerability in the state bar's particular system, but in the Odyssey portal more broadly, potentially impacting other Odyssey portal users. In fact, we did observe on our own that Judy Records appeared to have case information on its site from other jurisdictions around the country that appeared to be confidential. While Tyler was working on a technical solution to this matter, which they began to do immediately, we took the State Bar Court portal offline on their recommendation as a security precaution. In this period, we issued our press release. The story was picked up by the media. A significant development at that point was that Judy Records became aware of the issue via the media and voluntarily took all of the State Bar's records offline and then contacted us to discuss resolving the situation. So in the next bucket of time from about February 27th to March 14th, the investigation continued with a focus on determining what records had been posted and of those, which ones may have actually been viewed. In addition, we were of course focused on ensuring that non-public records were permanently purged from the Judy Records site. Throughout this process, we have received cooperation from Judy Records, who turned over all of the State Bar records in addition to analytical data about the page views. We did have an initial concern that the exploitation of the Odyssey vulnerability was malicious. In other words, we feared we may have been hacked. But the cooperation that we received from Judy Records, combined with the acknowledgement by Tyler of the Odyssey portal security vulnerability, led us to believe that that was not the case. It appeared instead that the vulnerability in Odyssey allowed in the Odyssey portal rather, allowed non-public records to be unintentionally obtained by Judy Records when they attempted to obtain the public records. It is important, I think, to note here that the non-public records were never available to anyone simply searching the State Bar Court portal in the normal fashion. They were available only by searching Judy Records because of the Odyssey vulnerability. It was confirmed by the media during this time that Judy Records had confidential case information from several other courts around the country, and Judy Records itself subsequently stated that it downloaded records from approximately 30 different Tyler Odyssey portals around the country, and they claim to have non-public records that could number in the millions. So this was certainly not an issue that was exclusive to the State Bar. The third bucket overlaps with the second. This was the period where we were remediating the portal. Tyler did provide a technical solution to the security vulnerability. It was installed and extensively tested by our own IT staff and the security firm, and we were able to bring the State Bar Court portal back up for public access on March 15th. In addition, we have been analyzing the case data and have updated counts of records that were available and viewed on the Judy Records site. As you can see here, there are substantially more non-public records than we originally thought during our very preliminary assessment. Total pages actually viewed is a little over 1,000, which is consistent with the earlier estimates. Among the pages posted, 188 did contain personal information, and of those, 6 had actual page views.
Mr. Mazer,
Yes.
Could you give us an example of what personal information means in this context?
Yes, the majority of it is references to mental health or substance abuse as a reason for inactive enrollment. That's.
Are you asking the definition of PII or how it played out in the data that was exposed?
I guess both questions, actually. I understand one is more broad, but it's generally, I don't want us to divulge anything we shouldn't be divulging, but certainly when we're talking about personal information, is it people's social security numbers and addresses?
I'll tell you
for
what
example?
it is.
Thank you.
Although the bar is not bound by the Consumer Privacy Laws or the Information Practice Act, we have adopted those definitions for purposes of this review. And personal information is limited to username or email address in combo with a password or security question and answer that would permit access to an online account, or individual's first name or first initial and last name in combination with one or more of the following: Social security number, driver's license, California ID, tax ID, passport number, military ID, or unique identification, account numbers or credit card or debit card numbers, so financial data, medical information, health insurance information, unique biometric data that would allow identification, information collected through a license plate recognition system, not applicable here, and genetic data. It does not include data that is publicly available and lawfully made available to the general public from government records.
Thank you.
We are aware of one record that had a social security number in it, but only one so far that we are aware of. Okay. So just want to provide a little bit of a technical follow-up and provide reassurance that the bar does take the security of its IT systems very seriously. In this case, Judy Records used a method for accessing Odyssey portal records that does not appear in IT security tools as an unauthorized intrusion or attack. That's why it was not triggered. They would not have been able to unintentionally get those records were it not for the security vulnerability that existed in the Odyssey portal. We do believe that our IT security posture is very strong overall. We undertake security assessments periodically to make sure that remains the case. We did conduct an application security assessment back in March of 2021, conducted by a private IT security firm. We also conducted a network security assessment just last September, conducted by the California Department of Technology. These are periodic reviews that will, of course, be done in the normal course. We have other security protocols that are, of course, maintained and deployed on a consistent basis. And as a result of this particular incident, we are, of course, conducting additional reviews, and we do plan to engage our IT security firm to assist in that effort. So I will conclude here. I hope you have found this recap helpful.
Thank you, Mr. Mazur. Any questions for Steve? Seeing none, I appreciate the, Mr. Tony.
I'm sorry. Steve, I'm just curious. You're talking and I'm interested, and what do you think of the Judy Records statement, what happened with Tyler's Technologies that they put on their website where they describe what they think happened? If you haven't seen it, it's okay.
No, I've seen it. I think I'm not going to comment on Judy Records sort of representations.
You don't have to.
Beyond what we've stated.
Okay, all right, fine, fair enough.
Okay. Thank you for the openness, transparency, and easy to follow presentation.
Okay.
That takes us to, so next on our agenda is the strategic plan, but we're going to take that up tomorrow morning at 9 a.m., which means that we will convene into closed session to consider those items listed on our closed session agenda. They are closed session minutes on the consent calendar. Item 7001, the threatened litigation concerning that what we just heard about, the case management system breach under section 11126 sub E sub 1 government code. Discussion regarding the sale price and terms and leasing price and terms for our building at 180 Howard Street in San Francisco under Government Code 11126 C7. The litigation entitled State Bar of California versus Legal Match under Government Code section 11126 sub E sub 1, and a discussion regarding potential litigation concerning the July 2021 California bar exam under Government Code section 11126 subsection E1. We'll take these items up in closed session, and then tomorrow morning, if there are any reportable actions, we will so note when we open up the public portion of the meeting. Okay. See you all tomorrow morning, unless you're here for the closed session right now. Thank you.
Doing closed session right now, Ruben?
Will be sent a link, Mark and Arnie, to
Okay.
join us in closed session by Zoom. We're doing closed session now. Yeah, we need you guys to participate because we'll lose the quorum if you don't.